corporations, it allows the big to get bigger, and it also pushes development towards trade secrecy. And if anything, we want more transparency in artificial intelligence development, not less. And the patent system, a patent means to lay open. That's what the word patent means. Mm-hmm. The patent system encourages public disclosures. For all of those reasons, PARA would help enable the United States innovation system to maximize its potential.
Thank you. Thank you, Mr. Chairman.
Senator Coons.
Mr. Chairman, thank you for this hearing today. I have a number of documents I'd like to submit for the record. Packet
Without
of
objection.
letters in support of PARA, a document from the Innovation Alliance on Section 101, an article and summary on AI patentability, and a law review article on the impact of patent eligibility. Congress passed the current Patent Act more than 70 years ago, defining a very broad scope for eligibility, essentially anything under the sun as made by man. And that worked fine for a half century. But as we've discussed starting 15 years ago, the Supreme Court issued a series of decisions that threw eligibility jurisprudence into disarray with new unworkable tests, with new judicially invented carve-outs, and new uncertainty. And every member of the relevant federal circuit has asked us to act to clarify it. I am eager to get this passed to unwind the hodgepodge of judicially created exceptions. And I'll have some second round questions, but let me bear down on this question about diagnostic tests and the patentability of genes. Ms. Peskin, if I could, I've heard arguments that PARA would make medical diagnostic tests less accessible rather than more accessible. As someone who lost several loved ones to pancreatic cancer, for example, this simple blood test that would allow for an early detection of emerging cancers, the melanoma passing into the brain that you referenced, very important. How does making sure medical researchers can obtain patent protections possibly lead to more breakthroughs and cures?
Thank you for the question. The Patent Act that you're referring to that was passed by Congress in 1952, the basic purpose of it was to encourage inventors to create and disclose new inventions by giving them a limited monopoly in exchange for making the invention public. Right. And that actually helps them with investment, to gain investment in order to bring it to commercial market and allow for a lot of Americans to have access to these types of tests. I don't disagree with Dr. Leonard that someone like herself, who is a specialist and wants to provide those same tests to her patients, should be able to do so. However, the inventor of those tests that devoted time and money and had investors that also devoted time and money into the invention should be able to license it to her in order to use it. And the very fact that she is able to recreate it is due to the patent system and the transparency within the patent system. So PARA, and the reason why it's so important is because what the Supreme Court cases have done is they've muddied the waters. Right. By broadening these exceptions and making it harder for the cases that have come after, so that there's a lot less predictability for inventors. And in
Dr. Leonard, forgive me, I've got 2 minutes. Dr. Leonard, I hear your concerns that you've raised with PARA that it could open the door to making some inventions in genomics patentable and create barriers to research. There is an explicit provision in PARA now in the revised version that says human genes are not patentable. Would building in an experimental use or research use exception to patent infringement help address this issue? And do you have other revisions you would suggest that might help us make sure that we are not causing unintended harm to the development of critical medical diagnostics?
So I can provide later potential language. I don't want to do verbal
I understand.
Rewriting. I have not found that diagnostics have been inhibited. I know that there is data that shows that there are 175,000 genetic tests on the market now and 10 to 14 more coming on each day. It's data from Concert Genetics. I find that medical genetics is not being inhibited by not being able to patent genetic sequences, human genes.
Dr. Yonker, you've done a huge amount of work, excuse me, Director Yonker, you've done a huge amount of work in this area. We've got clear disagreements. Help me understand how to square that circle and why we still might need to legislate in this area. Forgive me in the last minute.
Yeah, sure. So on diagnostics, look, like every innovation, it's a balance between incentivizing and protecting the innovation and investment in that innovation and public access to that innovation, okay? And like with anything else, you know, you need to have the innovation there in the first place for the public to even have access. And if we're talking at scale, for the United States to be maximizing its innovation output, if we don't have the stability of the law, then we're going to miss out on technologies that we don't even know about. So for Dr. Leonard and patients and others to have access to that technology in the first place, it has to have been invented. Then after that, we can talk about appropriate access. There's licensing. There is, as you indicate, Senator, the potential for a research exemption. There are other ways to address medical pricing and pricing for the diagnostics that have nothing to do with the patent system. But the threshold question for creating the innovation in the first place, the first leg of that balance, needs to be a reliable patent system.
And you said in passing earlier, but it bears repeating for folks who don't spend their lives on this, a company has a choice between keeping something secret, protecting it as a trade secret, or publishing it for the world, laying it open as a patent. And that choice is in part driven by whether or not there is predictability in patent eligibility jurisprudence. Is that correct?
That's absolutely right. And there is lots of evidence that since the recent Supreme Court cases, Alice, Mayo, and so on, there has been a push towards secrecy, both for diagnostics, also for certain AI types of technologies that Senator Blackburn was asking about.
Thank you very much. Thank you, Mr. Chairman.
Senator Welch.
Thank you very much. You know, the conflict here is, number one, should you get a patent on something you didn't invent, which is a gene? The patent system, as I understand it, has never been used to grant that. And then number two, there's a real debate here about whether a patent system would actually stifle innovation or enhance innovation. I'm sorry, I want to make sure I pronounce your name right.
Yanku.
Yanku, okay, thank you very much. We have enormous experience here with patent holders abusing the patent system.